on this fine October day, we will be talking about bankruptcy. Woo! So many people are interested in bankruptcy. What a delight. Now this particular presentation is going to be addressing homeowners, like individual homeowners bankruptcies and their effect on the association, meaning like from a collections perspective, right? Less so on like an association filing bankruptcy and like an association being in dire straits. So that may be a topic that we address another time, but for today, we're going to go Bankruptcy 101. How does a homeowner's bankruptcy affect the association? And away we go. Let's see. How do I do this? Oh, whoa. Okay, yeah. Okay, question number 1. What is the point of a bankruptcy? So generally speaking, why people file for bankruptcies, why individuals file for bankruptcies, is really to create a fresh start for those individuals. And the bankruptcy courts are really, and like the rules that govern bankruptcy want to create a fresh start for what they say the honest but unfortunate debtors. So people that just got too much debt, they accumulate too much debt, but they're honest folks. They're not trying to fool anyone or get away with anything or pull a fast one. They just need a fresh start, and that happens sometimes. So they created these bankruptcy rules and procedures in order to help those people out. To kind of oversimplify the process, bankruptcy is when a debtor surrenders assets that are not essential for basic living to creditors. And in exchange, they are released from those debts with a second chance for financial success. So that's kind of where that fresh start comes in. The bankruptcy laws ultimately try to strike a balance between treating debtors too leniently, such that a debtor might incur debt so liberally and waste assets without using them to pay any creditors, and balance that with being too harsh and maybe discouraging people from taking economically efficient risks to produce wealth for society. So this is all kind of a, part of the capitalism scheme that we're all a part of here, right? So that's kind of the point of bankruptcy. Now we're going to go into the types of bankruptcy next. And again, today's purpose, we're limiting to the 2 main types that individuals can file. There's also a Chapter 11, and there's various chapters that involve entities and things like that. But for today, we're going to start with a Chapter 7. A Chapter 7 bankruptcy is considered the liquidation bankruptcy. And the point of Chapter 7 bankruptcy is to wipe out general unsecured debts. Generally, in a Chapter 7, there's not enough assets to pay to creditors. So the point of it is to not pay back creditors, but it's just to wipe out those general debts, obtain a discharge for the debtor, and again, start fresh. Compare that to a Chapter 13 bankruptcy, which has a different goal. So Chapter 13 bankruptcy is what they consider a reorganization bankruptcy instead of a liquidation bankruptcy. And the point of a Chapter 13 is the debtor is going to be making payments to the bankruptcy trustee pursuant to a document called the plan, the bankruptcy plan, that gets approved by the bankruptcy court. And the trustee takes those funds that come in. They're supposed to make monthly payments of whatever amount, they calculate out with the court and the trustee and everybody. And those funds that go into the trustee get distributed to all of the creditors. Now I'm talking about creditors, and we're like, how does the HOA fit into all this? The association in these individual bankruptcies is itself a creditor. It's on the list of other creditors, like banks. Like if there's mortgages, the banks will be a creditor. A lot of times we see a lot of like the credit card companies with the credit card debt that comes around. So those kinds of things are considered creditors. The association in this context is also a creditor. But the goal of a Chapter 13 bankruptcy for the individual is to pay off the debts because there are assets available to make payments. And then any other general unsecured debt does get discharged at the end of the case. Okay, let's pivot a little bit now with those two kind of bankruptcy types in mind. In both of those cases, you're going to have pre-petition amounts and post-petition amounts that will need to sort of be accounted for. For pre-petition debt, those will be any amounts that became due before and including the day of the date the bankruptcy petition was filed with the court. So, for example, if a debtor files for Chapter 13 bankruptcy on June 1st, 2023, any debt on their account statement and the association's account statement that became due on their ledger before and including June 1st, 2023 is considered pre-petition debt. Post-petition, then, by sort of definition, by the opposite, is any amounts that become due after the bankruptcy petition was filed. So in our example, any amounts after, as of June 2nd, 2023, and moving forward is considered post-petition debt. That'll obviously include the ongoing assessments that are owed to the association. And sometimes the debtors get this confused, but rest assured, I'm here to remind you, and if your boards aren't sure, the debtors are responsible for post-petition or ongoing assessments, even though they filed for bankruptcy, and even while the bankruptcy is going on. The association may not be able to take any collection action if they don't pay, and we'll get into that a little bit later, but the fact that a bankruptcy is filed does not stop them or end their responsibility to pay assessments as they become due. And that's what I just said. Okay, so kind of drilling down now to how does a homeowner's bankruptcy affect an association? Okay, as I mentioned before, the association is a creditor in the bankruptcy case, and more specifically, it's considered a secured creditor. And the reason for that is because the association has an interest in the debtor's real property, which is the lien that the association has against the home or against the unit in the association that the debtor owns. You guys are familiar, obviously, with the collections kind of concept that the association has a contractual lien through the CC&Rs, and a statutory lien for the assessments, the late fees, the collection fees, and the attorney's fees and costs, right? So that lien is secured by the real property, and that makes the association a secured creditor, which is nice because that means that the association is not a general unsecured creditor like a credit card company would be. We have a little more stake in the game, a little more oomph that gives us more higher up priority, which is nice. So for example, in a Chapter 13 case, the association is generally towards the front of the line of creditors to get paid. Of course, before us is the bank or the mortgagee, the holder of the mortgage, the first deed of trust. They'll generally get paid before us, and any like state or government debts that the debtor may owe, those will also be ahead of us to the extent that any exist. But then after that, so we're usually pretty much second or third in line on the list of creditors, which is lovely. Great place to be. Let's see. Okay, the next thing to keep in mind, as soon as you get a bankruptcy notice, besides sending it to us, is to put all collection activity on hold. And that's the main takeaway, I think. And I think maybe the main thing you may even think of when you hear bankruptcy is that it's pretty much hands off on any collection activity. The day that bankruptcy petition is filed, an automatic stay goes into place over the debtor and all of their assets. And basically what happens is all of the assets of the debtor, like their car, their home, literally like clothes, jewelry, like anything that they have that's considered an asset, gets like scooped up and put into the bankruptcy estate. And once it's in there, the creditors can't touch it. And a creditor can get into a lot of trouble if they do violate that automatic stay. So you have to be pretty mindful when you do get these bankruptcy notices, or if you're mailed a bankruptcy petition, to make a note in that file that, hey, there is a bankruptcy that's ongoing here. Whether or not a debtor is delinquent to the association, it's still something to note, because you really shouldn't be, as the association, shouldn't be sending any delinquent letters. You shouldn't be making phone calls to try and collect. Arguably, we shouldn't be sending the account statements that are now required to be sent under that new statute that passed a couple of years ago, right? So if your assessments are monthly or quarterly, you're supposed to be sending out account statements at that same rate. Whether that violates the automatic stay or not is kind of up in the air. The conservative thing to do, or the conservative school of thought, I think, would be that it could possibly violate the automatic stay, just because it's saying like, hey, you owe this money. That might be seen as a collection action, and it might violate the automatic stay. So to the extent that you guys can put a note in your systems and put a pause on those kinds of things, the collection letters, the delinquent letters, and the account statements, I would recommend that you do that. I'm going to pause really quick because I do see somebody in the chat here. Oops, whoa. Okay, question regarding mandatory account statements. If the ledger has already been split into a pre-petition and post-petition amounts, hey, we just said this. Is it a violation to still send an invoice if it only contains post-petition amounts? Again, it's a little bit up in the air. This is a similar thing also, which you may not consider, which we're not really talking about today, but fines. Does assessing fines or sending a violation notice assessing fines violate the automatic stay? Some courts in the country have held that it does. No Arizona bankruptcy courts have dealt with that issue, so we don't have a ton of like specific guidance, but that's why I say when it's up in the air, I say that because some courts say it does, some courts say it doesn't. As I mentioned before, the debtors still owe the post-petition amounts. So, and sometimes you hear, I'm sure you guys hear a lot, the homeowners call up and say, I'm not getting my account statements. And you're like, well, you're in a bankruptcy, so we put it on hold. I do still think the conservative thing to do is to not send any, either pre-petition or ongoing with the post-petition amounts. But I do think that if we get to a point where where the chapter, if it's a chapter 13 bankruptcy, where the chapter 13 plan is confirmed, the chapter 13 plans these days almost always contain a provision in the plan that says that debtors are required to pay the ongoing directly to the association. And sometimes they even have language in there that says sending these kinds of statements does not violate the automatic stay. So once the plan is confirmed, I think that would change the analysis a little bit. But until then, it's a kind of a 50-50 shot on that. And I would maybe tend to think towards the don't do it side of things. Yeah, so the question is, can compliance and fines continue to be issued if and when applicable during the bankruptcy process? I say yes. I think you can still issue fines. Like I said, some courts have held that even that type of action is a violation of the automatic stay. But where I think I've sort of reached a compromise here in my mind is that the association can still assess the fines. And if the homeowners pay the fines, great. Good for them. If they don't, and if the association's like, hey, we want to enforce and also collect these fines that we've been assessing this whole time, or if they're asking us to file a lawsuit for an injunction and also a demand for those fines, and there's a bankruptcy going on, what I've come to understand and what we've done in the past on these is before we file that injunction lawsuit to enforce the rules and CC&Rs, we do move to lift the automatic stay, because now that I think filing the lawsuit and taking those actions to actually get the fines, I think that are more so than just issuing the fines, actually taking steps to collect the fines, to file the lawsuit, to make demands. I think that's probably even closer to getting to where you don't want to just file that with the bankruptcy going on. So before you pass go on the enforcement action and get that filed, I've been recommending, I think it's the safer thing to do, is to move to lift that automatic stay, which we'll talk about a little bit later. Just an extra step. And then once the bankruptcy court says you're good to go, then you're good to go. But as far as you guys continuing to enforce and issue fines, I think that's fine. But just be aware, it is an issue. I maybe wouldn't make any demands for those amounts, but to issue them, I think is probably fine. That's a good question. And it's just such a tricky area of law, quite honestly. And like I said, there's no real case law in bankruptcy in Arizona district courts that have dealt with that. So if that changes, we'll let you know. But it's an interesting thought for sure. Okay, moving on. Getting into debt that may be discharged. Discharged meaning just wiped out, potentially amounts that may need to be waived, right? So this happens at the end of a Chapter 7 case and a Chapter 13 case if the debtor takes all the steps he or she is required to take. So just kind of for your reference, a Chapter 7 case is going to go a lot quicker than a Chapter 13. A Chapter 7 case, I would say anywhere between like 3 to 6 months by the time it's filed to by the time you get the discharge, if the debtor does what they need to do. A Chapter 13 case, on average, lasts for 60 months, and that's when the plan is confirmed. It might take 6 months to a year before the plan is even confirmed. So you're in for potentially a 5 to 6 year bankruptcy process with a Chapter 13, which is a long time, but the trade-off is you're, in theory, getting paid through the trustee for the pre-petition debt that's owed. So you're getting money in, but it's a long time to leave things lingering and to leave things hands off with the automatic stay that's there. Chapter 7, much quicker. And you know, these debtors have to do certain things. They have to take certain financial management courses. They have to disclose certain documents to the trustee. And so there's a checklist of things that they need to do. And if they do them all, then they'll get a discharge. A typical discharge, again, discharges any general unsecured debt. So and I mentioned before, like credit card debt, that's general and unsecured. It's not secured, for example, by a lien against the home or a lien against the car for an auto loan. For associations specifically, general unsecured debt would refer to the fines or the monetary penalties that were assessed before the bankruptcy petition was filed. Because fines are not part of the association's lien, those are considered the association's general, that like if there's one area where that's a general unsecured debt, it's the fines. So it's possible that if a debtor files a Chapter 7 and they do what they need to do and they get their discharge, the association won't need to necessarily write off everything, all pre-petition amounts because of that discharge. But if to the extent there are fines that were owed pre-petition that are owed personally by the debtors, those will need to be written off and waived. All other amounts, so the assessments, the late fees, your management costs, your collection costs, and any attorney's fees and costs that are incurred, well, as I mentioned, are secured by your statutory and contractual lien. So those do not need to be written off. Those are still secured by a lien against the property, and they're still collectible. Once that bankruptcy closes, you can still foreclose to get those pre-petition amounts. If they in a Chapter 7, because Chapter 7 doesn't pay you anything, but that you can still leave them on the ledger. We can still foreclose unless the debtor. There's a process called stripping the lien, which is very dramatic, and but it's a possible thing that debtors can move in the bankruptcy court case to do. They don't often do it. I think I've seen it 2 or 3 times myself. It's not a very frequently done thing, but it's a thing that exists that might change that analysis. But generally speaking, the lien amounts are still secured against the property. and they still need to be paid by the homeowner unless or until the homeowner sells the property or no longer owns the property. Chat. Okay, let's see. Yeah. Okay, what to do in a Chapter 13 case, because this is a little bit more involved, as I mentioned. These go on for a longer time. There's a little bit more to do. So when you get, if you ever see a notice come through that a debtor filed a Chapter 13 bankruptcy, we do recommend that one of the first things you do is check to see, does this debtor owe the association anything? If they don't owe any pre-petition debt, for some reason the association's the one creditor that they've been paying, which is so nice of them to keep up with us out of all of their creditors, then you don't really need to necessarily appear in the bankruptcy. You do want to note that there is a bankruptcy going on, but you won't necessarily be included in the plan because you're not owed anything. So that never happens, right? So for the people that do owe pre-petition debt, they have debt dating back to 2020, 2019, and they owe, you know, $1,000, $2,000, $3,000, $4,000, whatever. You're gonna want to appear in the bankruptcy case and submit a proof of claim. And by you, I mean me. So you can send that to our office and we can get that done for you guys on behalf of the association and kind of monitor the case as it goes. But that is the key piece there, because there's a time frame by which you need to do that depending on when the petition is filed. So that's the kind of the key thing there. The first things first is you need to appear in the bankruptcy case and submit a proof of claim. The proof of claim will tell the bankruptcy court and the trustee and the debtor sometimes what the amounts are that are owed to the association. When our office appears, we also do include our attorney's fees and costs to do the proof of claim in the proof of claim. So we roll all of that together. So the association's owed, you know, $3,000 plus our $500 fee to appear. And that's all together and submitted to the bankruptcy court in what the debtor owes to the association in pre-petition debt. We always submit a ledger with our proof of claim, so that's why it's important, as someone else noted before, to split your ledgers. And sometimes I'll email or Mindy or Stephanie in our office will email and say, can you split these ledgers? And the reason we ask that is because we'll submit the pre-petition amounts to the bankruptcy court, because that's all they really care about, is paying anything that was owed at the time the bankruptcy was filed, going back in history. As I talked about before, the association will be added to the list as a secured creditor and will need to be included by the debtor in their Chapter 13 plan. Whoever else appears, all the creditors are supposed to do this, so that you could have a long list of creditors that appear and submit proofs of claims, and they all need to be included in the Chapter 13 plan that the debtor eventually puts together and proposes to the trustee and to the bankruptcy court to sign. It just includes a list of who the creditor is and how much they're owed, and then the order that they're going to get paid in. That's all. When I say Chapter 13 plan, that's that document that kind of spells out. It's like the master list of who's owed what and in what order. The debtor makes payments to the bankruptcy trustee each month, and the amounts of the payments are determined by the trustee and are set in part of what is included in the confirmed plan. The bankruptcy trustee then issues payments to the various creditors in their order of priority. And again, the association is usually second or third in line, so we do get those checks pretty early on in the 60-month process, so that's nice. Most debtors do stretch their plan 60 months, which is the maximum amount of months that you can do. So they, you know, a lot of times I see too where it's like a graduated monthly payment plan that the debtors will do. So like for months 1 through 8, they're going to pay $500, but for months, you know, 20 through 50, they're going to pay $3,000 a month. And the goal of that is to fund the bankruptcy estate to have enough money to pay out to the creditors. It is possible for the debtor to modify that bankruptcy plan over the course of that 60-month span. If they have significant increases or decreases in income or other factors that arise, sometimes they have like their mortgage payment will change, or, if they lose their job, or if they get a raise, or if they get, your income tax returns are kind of factored into that. So there's a lot of things that can change, obviously, over the course of 5 years. So the bankruptcy court and the bankruptcy rules do account for that. So it's possible to have a modified Chapter 13 plan, but it doesn't ever modify the amounts that the association is owed. It just modifies usually what amounts the debtors are paying each month. The association, unless the debtor objects to the amount that's in the proof of claim, the association will be included in the proof of claim for the amount that it puts in there. So that's why it's very important to kind of have our ducks in a row very early on, first thing in the case. And that way we can get everything that we're owed through that process. Pause, chat. Sheriff sales. That's way more exciting than bankruptcy. The question is, will you be covering sheriff sales? It was not part of this presentation, but I can certainly do my little spiel about sheriff sales if we have time towards the end. I want to get through a little bit more here on bankruptcy, and then we can pivot on some of the other collections topics as well. But that's a good question. It's semi-related, but not completely related to the bankruptcies. So we press on. Good news about a Chapter 13 is that the HOA will get paid the pre-petition amounts that it is owed. The bad news is it'll take several years, and collection efforts are put on hold during this time. Now, it is possible, and I would say even frequent, that a debtor files their Chapter 13, gets their plan confirmed, is really on track for the first 2 or 3 years, and then they just drop off the face of the earth and stop paying and whatever. It's possible that a bankruptcy can be confirmed and we can get some money in towards the pre-petition debt, but then the bankruptcy gets dismissed because the debtors stop paying usually, and that's fine. We will take what we get, and then once the bankruptcy is dismissed and closed, we can proceed with regular collections on whatever's left. So it is a lot. It's a lot of years, and there's a lot of contingencies and things that can happen. But the association's generally in a good position. It just needs to wait it out. What's a community manager to do? So I kind of covered this a little bit when we went through those first slides, but I wanted to have a slide that you guys could refer back to when you or your assistants are I have this thing from this bankruptcy court. What am I supposed to do with it? This is kind of that summary of what my recommendation would be to do, which I mentioned at first things first. See if the debtor who filed bankruptcy owes any amounts to the association. And again, you're going from the date that the petition was filed and backwards in time. So if they just paid, last month and randomly brought it current, cool. They don't owe any debt, but more than likely they probably owe something. If the debtor owes amounts, send to the attorney's office to appear in and monitor the bankruptcy proceedings. Split the homeowner's ledger into pre and post petition ledgers, and monitor the bankruptcy to see if any amounts will need to be waived, which is something that if our office is monitoring, we will let you know to see if anything weird happens, or if the bankruptcy does get dismissed, or if they did get a discharge. So there's a couple things that can happen, results that can come of this. So we usually keep you apprised along the way. As I've mentioned probably about 7 times by now, but in case you didn't know, homeowners do still owe ongoing assessments. The longer you wait, the harder it is to collect. That's just a good rule of thumb, even if they don't have a bankruptcy. If you have folks on your accounts that are 4 or 5 years and they just haven't paid anything in 4 or 5 years, and the board's no, we want to wait. Let them know. The longer you wait, the harder it is to collect. There have been instances and cases, and some of you managers that have been around for a while may be aware of a case that came out of 3 or 4 years ago now, where when you wait so long, you might not even be able to get your post-petition amounts. And there's a bankruptcy court case that basically ruled that, because it was the perfect storm of this debtor filed bankruptcy, and then there was a trustee sale, so then the lien went away because the sheriff sale happened. And the association was still trying to collect on the post-petition amounts that were owed by that debtor personally, and the court said, listen, they got a discharge, I'm wiping out the entire thing. So that was a worst case scenario for that association. But when I say there have been instances where a discharge has been applied to post-petition amounts and not just pre-petition amounts, really the underlying cause of that was the delay in the association pursuing the ongoing amounts. So I understand that we have boards sometimes that don't want to either spend the money or want to be nice and neighborly and wait things out, but there are sometimes some risks in doing that. So just to be aware, time is of the essence. Act now. Those who hesitate are lost, as they say. So what do you do? This is kind of moving into the next phase of this, is if you have somebody, a debtor, who has a Chapter 13 bankruptcy going on, and they're paying the trustee, and so the bankruptcy continues and the association's getting its little distributions towards the pre-petition amounts, the older debt. But since they filed bankruptcy in June, and they haven't, now it's going to be November, and they haven't paid July, August, September, October, no, it's 5 months later, they haven't paid any of the ongoing assessments. What do? You can't just collect. You can't just be like, hey, we're going to foreclose on you. Hey, we're going to send you a demand letter demanding these 5 months. You can't do it because of the automatic stay. In order to do it, in order to continue with your collection efforts, you'd need to lift the automatic stay that is in place. And that's what we're going to talk about next. But first, I'll pause. Nothing in the chat. Okay. Lifting the automatic stay, you can do it in a Chapter 7, but because the Chapter 7s go so quickly, usually we don't do a lot of them in Chapter 7. So mostly applicable, I say, in Chapter 13 cases. Most, as I touched on this a little bit earlier, but most Chapter 13 plans do require the debtor to pay the ongoing assessments amounts directly to the association, and usually through our office while the bankruptcy is pending, if it's something that we are handling. But it's nice that that language is in there. It didn't used to be included in the Chapter 13 plans, but the bankruptcy attorneys for debtors do seem to be putting that in there more and more, which is nice, because then the debtor can't be like, I didn't know what I was supposed to do. Like, it says it right in there. If the debtor is not making their ongoing assessment payments, I will usually prepare, if it's in our office, I'll prepare a big long email to the board that says, hey, we, as you know, this bankruptcy was filed on this date. The pre-petition amounts, all fine and dandy. We're getting trustee, bankruptcy trustee money to the pre-petition, but they're not paying their post-petition. And although it's only been 5 months, it could start to be a problem, right? And I'll kind of explain the process of what it means to lift the automatic stay. So before, as I mentioned, before you can go and just start your collection efforts anew on these post-petition amounts, you have to ask the bankruptcy court to lift the stay. It used to be a local rule that if you were asking the bankruptcy court to lift the stay and it was related to real property, like our situation is, that you had to send a demand letter to the debtor and to the bankruptcy attorneys, letting them know what the amount of post-petition debt is before you could file your motion to lift the stay. That letter is not required anymore under the rules, as of just recently, but I do prefer to still send a demand letter to the debtor and or the bankruptcy attorney for the debtor that explains to them that they are supposed to be paying the post-petition amounts, and they haven't been since June, and here's what the amount is, and to the extent that you intend to keep your home, pay these post-petition amounts, right? Or if you don't, we're going to lift the stay and collect. If the amounts are not brought current, the association then can file a motion, it's called a motion to lift stay, in the bankruptcy court case. And it just spells out the fact that, hey, this debtor is in bankruptcy, but they're supposed to be remaining current on ongoing assessments. They haven't been. Here's a ledger, a post-petition ledger, so you can see what they're behind. And the debtor would have a chance to object to that motion. But unless they have been paying, there's not much objection to make, right? So once the bankruptcy court reviews that, if the debtor hasn't filed an objection, the court will grant the request to lift the stay. And then in that case, it's like back to normal collections. So you can proceed with your normal collection activity. We could foreclose if it's foreclosure eligible. So from that point, there's kind of sky's the limit on getting back on track on those post-petition amounts. One thing I will say is that the reason I like to send the demand letter for the post-petition amounts is because I would say maybe 8 out of 10 times, or maybe 7 out of every 10, people will either bring their post-petition current after they get that letter, or they'll enter into a payment plan to bring it current over time. So it saves the time and the cost of actually doing the motion to lift the stay while getting the ongoing assessments current. And then usually, now that they're aware of it, they kind of correct the course and start paying those for moving forward. So it does, it gets their attention for sure. And if it doesn't, the remedies are still there for the association on the back end to foreclose and to sue over those amounts and get judgments and those kinds of things. So I think that is all I had there. Let me talk about, because someone had in the chat asked about sheriff sales real quick. And then if you have any other bankruptcy specific questions, go ahead and put those in the chat. But that's kind of the general overview about bankruptcy and things to keep in mind for managers. Ultimately, I get the sense that sometimes, you guys are the ones that get the notice of bankruptcy petition, right? Because you're usually the management companies or the stat agents for the association. So it comes to you and you're like, what do I do with this? My thought on it is, even if you're not sure, if we don't have a collections matter open in our office currently, like send it to our office to at least take a look at. We can tell you what deadlines are coming up and just kind of general information that the board would want to know. And sometimes maybe they only owe 2 months of assessments, and the assessments are $40 a month, so they only owe $80. It's like, is that worth filing or doing a proof of claim? And we can talk about those kinds of things with you, but I think it's a lot of times the management companies get these petitions and they're like, what is this? What do we do with it? How does it affect things? So hopefully that gives you guys a little sense of background and some things to consider, and to even just recommend to your boards, like, can we send this? Let us send this to the attorney to at least take a look and see what they recommend that we do. So that's the bankruptcy spiel. Now, sheriff sales are a little bit different. Sheriff sales are the manner in which the association forecloses on its lien. So to have a sheriff sale set, you first need to go to court, Superior Court, and file a foreclosure lawsuit and serve it on the owners, on the defendants. And if they don't answer, you can get a judgment by default, and the judge will sign that. And then you take your judgment, you being me, take your judgment, send everything to the sheriff with a writ. It's called a writ of special execution. And the sheriff takes that and sets their sale date. And once that sale date is set, the debtor has until the morning of the sale to pay the amount of the judgment plus interest up till that date, plus the sheriff's costs in full, or otherwise the sheriff will auction the property off. Now at the sheriff's sale, it's very, if you haven't been to a sheriff's sale, you guys should go because they're a lot of fun. I haven't been to a sheriff's sale, I don't think once this year, because people are paying off the judgment before the sale happens, which is good. People keeping their houses is good. But the sheriff sales are a lot of fun because the sheriff, there's investors there that are bidding, and sometimes you get in little bidding wars, and it's funny to watch. But so what happens is the sheriff will pull your judgment up and say, okay, here we have this property at blah, blah, blah address. And the way that it works is the bidding starts at the amount of the judgment that the association is owed. plus interest plus sheriff's costs. So say we got a judgment for the association of $10,000. They're owed, $7,000 in assessments, $100 in late fees, $500 in collection costs, and the rest in attorney's fees, $10,000. And then there's also $1,000 in interest and $1,000 in sheriff's costs and fees for them to do their thing. So that's $12,000 all in. The bidding starts at $12,000 for this home. For a home in Gilbert, $12,000, right? I mean, it's crazy. But the statute says, as a reminder for anyone that doesn't know, for foreclosure, the association can foreclose on its lien if the lien amounts total $1,200, or the amounts have been delinquent or unpaid for a period of 1 year. So we have some associations whose assessments are owed biannually, so twice a year, and they're $200 a pop, so $400 annually. That it's going to be a few years before they get to the $1,200, but in theory, after a year, the association could foreclose on the $400. It's unpaid for a year, or maybe by that time it's $600 a year and a half. And so for $600 you're foreclosing on somebody's house. So the statutes don't mess around, man. And yeah, I didn't write the statutes. Some people are like, that's crazy, and I'm like, I don't disagree, but them's the rules. And that's why sometimes some boards are like, I feel bad for foreclosing on $600, and it seems like a fairly low amount, I'll agree, but that's the remedy that the state legislature and all of their knowledge have seen fit to set the amounts at. So those are the rules for right now. I don't foresee them changing, but so like I said, at the sheriff's sale, we start the bidding at the amount of the judgment plus interest plus cost, so $12,000. So that's why you get your investors that are there that are like 12,100. Like, so, literally like an auction, they bid it up. Lately they've been getting up into like, the 80,000, 90,000, 100,000, and so whoever wins, whoever's there bidding, whatever investor gets the winning bid, they have a certain period of time to pay the sheriff, and they have to pay like with pretty much certified funds, or I think even maybe cash, but they have to pay them relatively short time period and get that money over to them. The sheriff takes the whatever winning bid. So say the house sold for 100, that particular winning bid is $100,000. So the winning bidder pays the sheriff $100,000. The sheriff takes their $1,000 for their fee, cuts our office a check for the $11,000 for the judgment plus the interest, and then that extra, the $100,000 minus the $12,000 judgment gets on deposit with the court, and it's basically excess proceeds, like almost like a trustee sale excess proceeds, where other creditors can apply for a piece of that. The debtor, now former owner, can apply to have that overage if they want. To the extent that the association is owed fines, like fines were part of the judgment, but they weren't part of the lien, that this sheriff could foreclose on. So on top of the $10,000 lien, there was also $2,000 in fines that were owed. The association could also apply for a piece of that extra, $88,000. And we can say, oh, we were also owed $2,000 personally that the homeowner owed personally. You can collect from that excess proceeds amount as well. And then, so that investor who made that $100,000 bid becomes the new owner of that property, with the caveat that the debtor does have a 6-month redemption period to bring everything current and then keep their house. But if they don't, then the investor is the new owner and they owe the assessments for moving forward. So it's an interesting process for sure. Like I said, our office, at least, I don't think I've been to any. I think Dan's maybe been to 1 or 2 this year, because like I said, the debtors, the defendants, have until the morning of the sale. The sales are always Thursdays at 10 a.m. If anyone's downtown Phoenix, Thursdays at 10 a.m., check it out. And they can pay up until literally 9:59 the day of the sale. and they have to just pay the judgment interest cost amount. So if they can bring $12,000 down to the courthouse and pay, then the sale is canceled and the association gets that money in that manner. So the goal is obviously not for the association to get homes or properties, it's to get the funds from the sale. So that's the good news here, is that that's been happening a lot more in the last year or two, as people are actually paying and keeping their homes, which is preferred. Okay, couple questions in the chat. If a homeowner's bankruptcy has been dismissed by the court, how many times can the homeowner refile a petition for bankruptcy? I know a homeowner who has filed again after being dismissed, I assume for not cooperating with the trustee. Great question. So the way that this works is the trustee can dismiss a bankruptcy for a list of reasons. The main one that I see is that, like I mentioned, the homeowner stops making their monthly payments towards the plan. And if they're behind on plan payments, the trustee's like, see you later, we're dismissing this. Another reason I often see, which I think is weird, is that debtors are supposed to provide their tax returns, and sometimes they just don't. And a trustee can dismiss the bankruptcy for that reason. And so there's a list of reasons for not providing certain documents and things to the trustee. So there's a list of reasons that a trustee can dismiss a bankruptcy. But if the bankruptcy gets dismissed, the association does need to wait until it like formally administratively closed before it can proceed with any collection efforts. But the debtor can refile for bankruptcy. And I see this a lot too. I know this person said they know a homeowner that does this. I think we have 2 or 3 in our office right now. There's no, in the bankruptcy statutes, there's no limit on the number of times that you can, but there is a limit on the frequency that you can do it, and if the automatic stay is in place. Because after, I think it's if you file more than 3 in a short period of time, the presumption kind of switches, meaning the stay is not automatic. The court, you basically have to come to court, you being the debtor have to come to court and say why the automatic stay should be in place because you keep filing bankruptcies. And sometimes the remedy there for the bankruptcy court for people that habitually file is that the automatic stay might not ever be in place for your millionth and first bankruptcy case. So it's not like the bankruptcy court says you can't, like, we're kicking out this case and we're not doing the case, but they say you can file this bankruptcy and we'll do the bankruptcy, but there's no stay in place. So your creditors can still take collection activity, potentially foreclose. So that's kind of the remedy there. So that's a really good question, because we do see that a lot where it's like, oops, I messed this one up, let me just file again. There's also a mechanism for creditors to a basis to lift the stay, that kind of almost similar to fraud, or that they're filing these bankruptcies just for the sole purpose of avoiding collections, or to defraud their creditors, or to frustrate the purpose of collections. Those are all, again, bases to lift the stay, not necessarily to dismiss the bankruptcy, but to lift the stay as to you, the creditor, who can then move forward with your own remedies. So yes, that's a really good question. Let's see, any other questions? I think that's the last question I see in the chat. If you have anything else, please feel free to put it in the chat. My email's on the screen here if you guys don't have it already. If you have any bankruptcy related questions or want me to take a look at anything, please feel free to reach out. Phone number's up there as well. My extension's 404. It doesn't have it on there, but if you guys want to reach out directly. But yeah, otherwise that is all I prepared for the day. I think I know I've been talking to Dan. I don't know if Dan's still on, but we do want to do like it's been a while since we've done a general collections sort of class, like lunch and learn class like this. So I definitely want to put one of those together again, just to go over the basics. I know we have a lot of new managers in the industry coming up, or just managers that don't deal with it very much, quite frankly. And so just go over foreclosure and the process and what it looks like. And I think that would be helpful as a topic maybe for moving into next year. So Yeah, I really appreciate your guys' time and jumping on today. I know bankruptcy is kind of like a snoozer of a topic, so kudos for jumping on, and hopefully it wasn't too terrible. But yeah, that's all I have. I appreciate you guys for coming on. I don't know if you can unmute yourself. I don't know. I don't know how to run this. This is not that's above my pay grade. It's good to see everyone. And we'll be in touch soon. Hope see you guys in person hopefully soon.